Hello and welcome to ABI Podcast. This is Melissa Jacoby. I'm the Resident Scholar of the ABI for Spring 2016 and the Graham Keenan Professor of Law at the University of North Carolina at Chapel Hill. So listeners to this podcast know that Congress sometimes sees a need to enact bankruptcy laws or elements of a bankruptcy law that are applicable to debts that have already been incurred. Some of that discussion is going on right now regarding the financial crisis in Puerto Rico. We have a great guest to talk with us about some of the constitutional issues that sometimes get raised here, Professor Charles Tabb of the University of Illinois. Professor Tabb is the Mildred Van Voorhis Jones Chair in Law and also a former ABI Scholar in Residence. He's long taken a historical approach to bankruptcy law and its constitutional elements, so really is a perfect guest for us today. And he's recently published an article that's right on point for some of the questions that are being raised about the Puerto Rico legislation. The article's called The Bankruptcy Clause, the Fifth Amendment, and the Limited Rights of Secured Creditors in Bankruptcy, which he presented and published as part of the ABI Chapter 11 Commission's conference proceedings and ultimately published in the Illinois Law Review. So welcome, Professor Tabb.
Thank you, Melissa. It's a delight to have a chance to speak with you today.
So let's go back to the background, at least, of your article. So you did not have Puerto Rico in mind when you wrote this article. What prompted you to write it?
Well, I wrote it, of course, as part. I embarked on it as part of the symposium. The University of Illinois and the ABI, with their Chapter 11 study, partnered to put on the symposium, which you also, of course, were a valuable part of. And I started to explore the question of what rights secured creditors had. The concern I had that I was reacting to, which actually a number of people, including you, Ted Janger, and some others, dealt with in different ways in the papers, there's a concern that we were looking at that secured creditors were always getting any sort of incremental value, the going concern surplus or whatever, and I was concerned about that, and so assumed that there was in fact sort of this bedrock floor of constitutional entitlement below which secured creditors couldn't be taken. We'll probably discuss sort of an iconic statement that Justice Douglas had made in a case close to 80 years ago now, and I, like most people, had assumed, sort of without more, that the received wisdom that there was in fact such a constitutional entitlement. So really, just as part of the background of starting to try and work through what might not be able to be done as policy matter to deal with secured claims in Chapter 11 reorganizations, I started looking into that assumption and discovered that in fact it perhaps is a situation, the proverbial "the emperor has no clothes," that, wait a minute, that's in fact quite dubious. The only basis for it was really a 1935 decision, the Radford case, which we'll probably talk about some more, in which, for the first time, sort of out of the blue, the Supreme Court invoked, in very oblique language, takings as a limitation on what can be done to secured creditors in bankruptcy. And following that, there were some cases, one of which made this statement about the entitlement of secured creditors. But I discovered, upon looking more closely at the historical record and the evolution of the case law, and then also really trying to look at first assumptions in terms of the constitutional structure, that the received wisdom, which is that secured creditors have a constitutional right to the value of their collateral, which is protected by the Takings Clause, is simply wrong. That is not, in fact, the best view. Now, the Supreme Court, in a case 34 years ago, didn't squarely hold that. They recited favorably the Radford case, and we'll talk about this historical development. But I think that's wrong, and that the better view is that, in fact, takings is not a limitation on what can be done pursuant to the Bankruptcy Clause with regard to the rights of secured creditors in bankruptcy. So, as often happens, you and I both know this in research, you start just looking into something, just assuming this will just sort of set the stage for your argument, and you discover that the whole stage is different than you thought. And so that's sort of where it went.
Well, I do completely agree with you that when you go into a question with a somewhat open mind or not expecting to see something, you never know where it will take you, and sometimes it's the most relevant directions that you can go. So there are sort of two levels to your project. There's the one that is more likely to be contested about the limits on the Bankruptcy Clause of takings. But then there's a background that I also think is very relevant to these Puerto Rico discussions of that takings is less relevant to a lot of questions in bankruptcy than people might think. So could you just give us an elevator pitch on sort of how takings and bankruptcy intersect, sort of generally that pretty much everyone agrees on, and then where you are pushing the envelope a little bit more?
Absolutely. No, that's fair. The essentially uncontested, everyone agrees on it aspect is that essentially anything can be done to secured creditors in terms of staying them, delaying them, preventing them from foreclosing. They cannot exercise their state law remedies, their rights of acceleration, et cetera, et cetera. Really, the only thing under the received wisdom, which the pushing the envelope part of my thesis said was wrong, is the necessary entitlement to the protection of the value of the collateral. But it's beyond contest at this point, not with the pushing the envelope, but under accepted doctrine, that secured creditors can be delayed extensively by a bankruptcy case without there being a takings problem. Indeed, Melissa, in the relevant cases where this has been most clearly noted, takings isn't even discussed. It's not even on the table as a possible problem. And I mean, I can give you some of the historical background of that, but that's really the notable thing. Essentially, if you look at what a secured creditor has, right, they have a bundle of rights. I mean, there are a number of different entitlements they have pursuant to their contract outside of bankruptcy with their debtor in terms of declaring defaults, accelerating the debt, going forward with foreclosure, and so forth. There's a whole grouping of rights they have. Essentially, the Supreme Court has, at this point in a series of cases, clearly held that all of those rights can be taken away except possibly this right to eventually, in some way, shape, or form, to get paid the liquidation value of their collateral. Everything else can be taken away. And as I said, they don't really even raise takings as an issue with regard to that.
So let's break this down a little bit more. Now, you've been focusing on the rights of secured creditors, and let's just be clear about why you're doing that as opposed to creditors who do not have a security interest, do not have collateral. What's the difference for takings purposes?
Right. The point I'm making there is, again, taking away my envelope pushing point and accepting as true, even though I think it's false, but accepting as true the fundamental statement that the Supreme Court made in a 1935 decision, the Louisville Joint Stock Land Bank versus Radford case, known everybody as the Radford case, an old Brandeis decision, which was sort of resurrected and ratified in the 1982 decision, Security Industrial Bank, in which the court said basically there's a difference between the property right held by a secured creditor